Hi friends, welcome to Learning Space. Today we are going to start a new discussion and this is going to be the Polity MCQ discussion. So before we get on to the actual questions, I need to stress upon 2 points here. One is we have not done the Polity theory part till now. So we are directly proceeding to the MCQs. Because of that, I will be stressing on some of the points which I feel very important for you guys. Second thing is, it would be good for you and beneficial for you if you actually do it in the format of a test series only. Just download the PDF beforehand, try solving the questions and then watch the video, because then I think it will help you even more. With this introduction, I think we can proceed on to the question and answers of this session. The very first question is, the preamble reveals 4 ingredients or components. Which of the following are the said ingredients? Now let us look at the options. The options are source of authority of the Constitution, the nature of the Indian state, the objectives of the Constitution. Now these 3 things, yes, they are a part of the Indian preamble. Now as far as the 4th option is concerned, I think that is where a lot of students can commit a mistake, because there is one date that is mentioned in the preamble, but people may get confused if it is the date of enforcement or if it is something else. So let us take a closer look at the preamble. So here the preamble says, "We the people of India." This is where the entire constitution derives its source of authority from. So the first option that says source of authority is nothing but the popular sovereignty or the power of the people that is described in the preamble. So the first option is correct. Now as far as the second and the third are concerned, the nature of the Indian state and the objectives of the constitution. This is the nature of the Indian state. The Indian state to constitute India into a sovereign, socialist, secular, democratic republic. These are nothing but the nature of the Indian state. And now let us look at what the preamble tells about the ideals that we have to follow. These are the ideals to secure to all its citizens. What are we securing here? Some of the ideals. Which ideals? Something like justice, social, economic and political, liberty of thought and expression, equality of status and opportunity, and fraternity. Now these are nothing but your ideals that we are looking towards the Indian constitution. Now let us look at the 4th option. The 4th option is nothing but the date of enforcement. Here it says that there is one date, 26th day of November of 1949, we do hereby adopt, enact and give to ourselves. So there is no word of enforcement given anywhere in the preamble. Therefore, the correct option would be nothing but 1, 2 and 3, because the date of enforcement is not given in your preamble. So, here is the explanation part of it. The statement 1 is correct because the preamble gets its authority from the people of India. The statement 2 is also correct because these are the definition of the nature of Indian state. The statement 3 describes the ideals of a constitution. Yes, we have seen it already. And the statement 4 describes the date of adoption and not the date of enforcement. Let us look at the question number 2. Consider the following statements regarding the preamble of the Indian constitution. The preamble is justiciable, that is, its provisions are enforceable in the codes of law. The preamble is neither a source of power to the legislature nor a prohibition upon the powers of the legislature. Now, anybody who has done some amount of preparation may know that this statement is correct statement. Now, let us look at the third statement. The preamble has not been amended by the constitution. Again, everybody knows the preamble has been amended just once, and that is why this statement is wrong. So the correct option, even if you don't know what is there in your first option, don't worry. The correct option is answer number 2. The second statement only. Now why do I say that the first statement is wrong? That is because of this statement, the preamble is justiciable. As soon as you see this, because it's described everywhere, the preamble is non-justiciable in nature. Just because a word is given in the preamble, you cannot stand in front of the court saying that something is there in the preamble, therefore we need that as a right. Preamble is non-justiciable. You cannot go to the courts just because you have something in the case of your preamble. Let's take the Constitution. Yes, you can go to the court for anything that violates the Constitution, but not in the case of preamble. So the first statement is wrong and the third statement is obviously wrong because everybody knows it has been amended once. That is 3 words, which is the socialist, secular and the word integrity, that has been added to the preamble by the 42nd Amendment of the Constitution. So the answer is B only. Statement 1 is preamble is non-justiciable. We have already seen this. Statement 2 is correct, the only correct statement. And again statement 3 is wrong because it has been amended once and the amendment number is the 42nd Constitutional Amendment Act. Now this is a very peculiar thing because everybody knows, and keep in mind 42nd Amendment Act is very important with regard to prelims because that is called as the mini constitution in itself. Many provisions are added to the present constitution just by this one amendment act. So pay extra attention to this particular amendment. So then comes the question number 3. Now this is regarding your fundamental duties as prescribed in your Article 51A of the Constitution. So let's look at the options. The fundamental duties are enforceable by law. Yes, if the Parliament wants it, they can enforce your fundamental duties. Now let us look at the option number 2. They may help the courts in examining and determining the constitutional validity of the law. Yes, it is correct. Anything that is kept in your constitution serves as a base for the courts to proceed and to check the constitutional validity of any case that is in front of it. So then comes the third option. It was incorporated by the founding fathers of the Constitution to inculcate a sense of responsibility among the citizens. It may sound correct. Yes, it may sound as if it is correct, but then there is a catch in this question. Let us look at this word, the founding fathers. The fundamental duties were not inscribed originally in your constitution. It was added later on based on your Swaran Singh committee. This is how UPSC can make you fall in a trap. Please do not fall into that particular trap. Just pay attention to such things. It may sound familiar, it may look as if it is correct, but actually when you look at deeply, such words can actually ditch you. So the correct answer is nothing but 1 and 2 only. Let us look at the explanation part. Statement 1, yes, they can be enforceable by law. Hence the Parliament can provide for the imposition of appropriate penalty or punishment for failure to fulfill any of them. Statement 2, again it is correct. The constitutional validity of any law can be determined using your fundamental duties as a base. Coming to the third statement, the Swaran Singh committee, that is what recommended the fundamental duties to be added in your constitution, and that was not added by your founding fathers. Question number 4. This again deals with fundamental duties. I have made this entire session as one particular thematic kind of questions. Either we'll do all the fundamental duties questions together and then we'll proceed on to the other questions. There will be 3 or 4 questions repetitive of the same nature. So this is again regarding to your fundamental duties. All fundamental duties were incorporated in the Constitution by the 42nd Constitutional Amendment in the year of 1976. Now this is again wrong, because there were some things, there were some duties which were added later on, like for example your right to education. Your 86th Constitutional Amendment Act itself added one such fundamental duty. Coming to the second statement, the Swaran Singh Committee incorporated 8 fundamental duties in the Constitution and all of them were incorporated in the Constitution. Again, this may sound correct, but actually it is a wrong statement. The incorporation of 8 fundamental duties was not done. Swaran Singh Committee, they recommended 8 duties, but not all of them were incorporated into your Constitution. So the answer is neither 1 nor 2. Let us look at the explanation part. Statement 1 is wrong because the duty to provide education to the children between the age group of 6 and 14 years, that was added by the 86th Constitutional Amendment. Statement 2 is also wrong because the entire recommendation of the Swaran Singh Committee was not incorporated. The following are the ones that was not incorporated, though they were present in the original Swaran Singh Recommendation Committee. So they are the penalty for non-compliance to observe any of the duties. Even if you don't observe a fundamental duty, that can also be penalized. That is what this statement means. Coming to the second duty, the duty to pay taxes. This was again a statement that was made in your Swaran Singh Recommendation Committee. And the third was, no law that imposes such penalty can be called in question in any court. Now, these 3 things were not incorporated into your Constitution. Now, coming to question number 5, which of the following are the fundamental duties present in the Article 51A? Now, this may sound very simple, but actually there are a lot of people who commit a mistake in this particular question. Let us look at the answers. To abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem. Yes, this is one such duty. To promote harmony and the spirit of common brotherhood, that is also included in your fundamental duty. But let us look at the option number 3 and 4 here. To protect and improve the environment and to safeguard forest and wildlife. This may sound as a very good fundamental duty. Yes, this is a very probable case of being present in your Article 51A. But do you think it is actually present in your 51A? No, it is not. Because this is a directive principle of state policy and not a fundamental duty. This is where a lot of people can commit a mistake, because this may look as if this is present in your fundamental duty itself, because protecting environment, many may think that this can be a duty of a normal citizen, but actually this is present in your DPSP and not into your fundamental duty. The same goes with the fourth statement also, that is also present as a part of your DPSP and not fundamental duty. Hence the correct answer is 1 and 2 only, and the 3 and 4 are nothing but your DPSP. So the statements 3 and 4 are present in the directive principles of state policy under the articles of 48A and article 49 respectively. 48A, please keep this in mind, this is a newly added article, like after the DPSP came into picture, this was one of the recently added articles. So consider the question number 6. The following statements are regarding Article 21A. Now, Article 21A provides free and compulsory education to all the children of India. Yes, can sound very familiar, but the statement is actually a wrong statement. Let us look at why that is wrong. This provision was added by the 93rd Constitutional Amendment. Now, this is a blunder mistake. It was added by the 86th Constitutional Amendment Act, a very simple thing. And now let us proceed on to the third thing. Before this amendment, there was no provision in the Constitution for free and compulsory education. Again, when you come across terms like there was no provision, this is alone present. Now, when you come across such subjective terms, please make sure that you do not fall under this trap, because when you bring under such holistic terms, pay extra attention to terms like only, alone, there is no such provision. Do not fall a trap under this kind of words. So again, this is a wrong statement. The answer is none of the above. Statement 1 is wrong because it does not give education for all the children of India, but only to the age group of 6 to 14 years. This may look very familiar, but at the time of the examination, you may go wrong even in this very simple answer. Then comes your second statement. It is added by the 86th Constitutional Amendment Act. And regarding the third one, it was already present. Your education, giving provision of education to children, was already present under the Article 45 in your Part 4. However, this being a directive principle, it was not enforceable by the courts. Now, after making this as a fundamental right under Article 21A, there is a scope for judicial intervention in this regard. Question number 7, that is again with regard to Article 21A. This right covers not only elementary education but also higher education. Again, we just now saw only 6 to 14 years, and anything above that is not covered under this particular article. Therefore, this statement is wrong. The right to education is a self-executory right. A very new term, can be a new term for some of you. So, right to education is a self-executory right? No, it is not. What do you mean by self-executory right? Yes, we will see that in your explanation part. Right to education is also embodied in your DPSP and fundamental duties. Yes, it is a correct statement. So, the answer is 3 only. Statement 1 is wrong as Article 21A covers age group of 6 to 14 years. Certain fundamental rights, they do not need a separate legislation for that to be executed. And such fundamental rights, they are known as self-executory rights. However, others like your Article 21A, for example, they need a separate legislation for execution. Some of the rights which need a separate legislation are your right to free and compulsory education, prohibition of traffic in human beings and forced labor, which is covered under your Article 23, and prohibition of child labor. Now, these are the things we need a legislation to enforce that, because this is not a very simple thing like right to equality, for example. That is like a very universal right. On the other hand, for such things, for example, your case of child labor, you need a legislation to enforce it. Such enforcing mechanism is what is being given under your Right to Education Act of 2009. Now, right to education comes in various forms in our constitution and not just in your fundamental rights. So, it is covered under Article 45 DPSP, 51A of fundamental duties and 21A, which is your fundamental right. Now, the question number 8, the Supreme Court declared the education as a fundamental right in the case of Vaman Rao. The second statement is the 86th Constitutional Amendment Act brought in Article 21A, by which the scheme of right to education was enforced all over the country. Now, the first statement is a fact-based statement. It is wrong. Vaman Rao case was for something else, and this education as a fundamental right was made by Unnikrishnan versus the state of Andhra Pradesh. That is the case wherein the education was made as a fundamental right in the year of 1993. Now, coming to the second statement, again this is wrong, because this 86th Constitutional Amendment Act brought in Article 21A, but that did not mean it enforced it all over the country. Enforcement mechanism is different, your article is different. So, the answer is neither 1 nor 2. Coming to the explanation part, it is J.P. Unnikrishnan versus the state of Andhra Pradesh that recognized education as a fundamental right. And coming to the 86th Amendment, this was introduced a very important thing. People may go wrong in this, and a very conceptual question. So please pay attention to it. It is introduced to recognize elementary education to the children of the age group of 6 to 14 years as a constitutional right. However, to enforce this, it needed to be supported by a legislation so as to prescribe the manner by which this provision can be implemented. So this 821A is nothing but your article that prescribes the intention of the government, and it will serve as a constitutional right for the citizens to put a case against the state. Now let us look at what RTE does. RTE, on the other hand, that provides for the framework. This is the key word here. RTE 2009 provides for the framework under which the state had to provide free and compulsory education to the children. So this laid a framework by which you have the following provisions like appointment of trained teachers, laid down the standards of student-teachers ratio, it laid down the infrastructure that is needed in your school. So all such technical aspects was laid down under your RTE 2009. To sum up, to put it in very simple words, RTE was an act to implement and give effect to your Article 21A. So if you consider RTE or your Right to Education Act as the means to achieve Article 21A, which is the end. This is a means to an end. Now, just a very quick fact, this term means to an end is very important even for your ethics paper. It comes under Immanuel Kant's ideology. Just a quick fact, please look at that also. Now coming to the question number 9, consider the following changes brought into effect by the 86th Constitutional Amendment Act. A new Article 21A was inserted into the Constitution. Yes, correct. It added into Article 45 the statement of the state shall endeavour to provide for free and compulsory education for all children. This may sound correct, but actually this is a wrong statement. It also added a new duty in Article 51A that reads that it shall be the duty of every citizen of India to provide opportunities for education to his child between the age of 6 and 14 years. Yes, again a correct statement. So the answer is 1 and 3 only. Statement 1 and 3 are correct. However, the provision given in the statement 2, this is the provision that was given in the question. Now actually what happened was that under this 86th Constitutional Amendment Act, this particular provision, this was replaced or substituted by this provision. So this was the new thing that was added by your Article 86th Constitutional Amendment Act. The state shall endeavour to provide early childhood care and education for all children until they complete the age of 6 years. Now you have to pay attention to this particular statement because the DPSP that actually tries to attain the future ideals of the state. What and how the state should proceed in the future to attain a progressive welfare state. That is the aim of your DPSP. Now when this article was itself made it as a fundamental right, the DPSP should focus upon something else, and that is nothing but early childhood care and providing education for children until the age of 6 years. Now this is what the state should strive towards in the future. Now coming to the 10th question, consider the following statements with regard to Sarva Shiksha Abhiyan, which is recognized by the government as the vehicle for implementing RTE Act. Now when you look at such broad statements, do not get scared. UPSC can give you even bigger than this. So do not get scared by the length of the question. Then comes the options. The fund sharing pattern, a very important thing. The fund sharing pattern in the SSA for all the states is to be in the ratio of 60:40 between center and the states with effect from the year of 2015-16. This is a wrong statement because this is not the practice for all the states. This is where the flaw lies actually. SSA is a centrally sponsored scheme. Yes, it is correct. The Ministry of Women and Child Development recently launched Shagun, a web portal for SSA. Now, Shagun is a very important thing. Yes, it is a web portal for SSA. However, the wrong statement, the wrong part in this statement lies in this part. This is not done by your Ministry of Women and Child Development. Rather, it is done by the Ministry of Human Resource Development. So, the answer is 2 only. Statement 1 is wrong because the 8 northeastern states, which is Arunachal Pradesh, Assam, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim and Tripura, and your 3 Himalayan states, which is Jammu and Kashmir, Himachal Pradesh and Uttarakhand, they have a special provision in any of the schemes of a government, and that is they have a different ratio of fund distribution. That is, they have this ratio 90:10. Your center will contribute 90% of the fund in your CSS, whereas the states need to contribute just 10%. This is a special concession only for these particular states. Now comes the most important part. What do you mean by centrally sponsored scheme? Now, CSS are schemes that are implemented by the state government. Very important, they are implemented by the state government and they are largely funded by the central government with a defined state government share. So, it is implemented by the state government, funded by the central government with a definite state government share. Now, they are extended by the central government under your Article 282 of the Indian Constitution. This is very, very important because this falls under 282, not something everybody would be familiar of. So, such articles, please familiarize it with as and when I tell you such articles. So, this was launched by MOHRD and not by the Ministry of Women and Child Development. So, this comes a very important question. Both Gopalan case and Menaka Gandhi case are very, very important. So, please pay extra attention to this question. The Supreme Court has taken a wider interpretation of the Article 21. Now, as soon as you see this statement, please make this as a wrong statement because Gopalan case is wherein you have narrow interpretation of your constitution because of the expression procedure established by law. So, in the Menaka Gandhi case, the due process of law, yes, that is correct, was followed and the Supreme Court held that the personal liberty relates to the liberty of the person or the body of the individual. Now, this may look correct, but actually the personal liberty, this part of it was actually held in your Gopalan case, whereas in your Menaka Gandhi case, in addition to this, we had something like human dignity. That is where Menaka Gandhi case stands apart. The personal liberty was expanded into the realm of human dignity and that is why this statement again is wrong. So, the answer is neither 1 nor 2. Quick look at your history. A.K. Gopalan, he was a communist member and he was independent India's first leader of opposition in the year of 1952. So, what happened was he was illegally detained under the Madras jail and he fought against such illegal detainment under your Preventive Detention Act of 1950. He was detained under the Madras jail and he fought against that in the court and thus came the Gopalan case. And with regard to Menaka Gandhi, she is the Minister of Women and Child Development. She is a very famous animal rights activist and environmentalist. Now, with regard to Menaka Gandhi, what happened was her passport was curbed by the Janata government and she fought against that, saying that her passport is nothing but her own personal liberty and she has the dignity to lead a peaceful life irrespective of the government. So, such a wider interpretation was held under the Menaka Gandhi case and that is where you have the wider amplitude of Article 21. A quick explanation. Article 21 in the Gopalan case was a narrow interpretation, because this is where the crux of the case lies, because it was available only against arbitrary executive action and not against arbitrary legislative action. This was later corrected in your Menaka Gandhi case. Like arbitrary legislative action is that anything, be it anything, if it is inscribed in your law books, even if it is not just, even if it is not fair, just because it was established, the procedure was established in your law books, the court before the Menaka Gandhi case said that such things are valid in the eyes of the law. Now the second statement is also wrong, because in the Menaka Gandhi case, the Supreme Court took a wider interpretation with this particular aspect, that is your human dignity. Every individual has the right to live with human dignity apart from or along with your personal liberty. A quick comparing and contrasting of Gopalan and Menaka Gandhi case. No person shall be deprived of his life or personal liberty except according to the procedure established by law. This is where the principal flaw in the case of Article 21 before it was amended lies. It held that Article 21 is available only against arbitrary executive action and not arbitrary legislative action. That is, anything that is established by law was held to be valid even if it was unjust or unfair. So this was a very narrow interpretation of the Constitution. So then this was rectified in your Menaka Gandhi case. This ruled that right to life and personal liberty of a person can be deprived by a law provided the procedure prescribed by that law is reasonable, is fair and just. In other words, it has introduced the American expression, again a very important thing, American expression of due process of law. Now Article 21 by this provision is available not just against your arbitrary executive action but also against your arbitrary legislative action. So this had a widest interpretation of Article 21. So coming to the last question, consider the following statements regarding the Article 21. Right to sleep is a part of Article 21. Yes, it was recently added. Protection under Article 21 is available only against arbitrary executive and not from arbitrary legislative. We just now saw this is a practical question of the one theory question that we saw before. So this statement is wrong because it was amended under your Menaka Gandhi case. So the answer is A1 only. The right to sleep has been recently added as a fundamental right in Article 21. A very quick interesting fact is that this ruling was in response to the police action on a sleeping crowd of Baba Ramdev's rally at Ramlila Maidan. So they rallied against black money in your foreign tax havens, and the police interrupted their sleep, and that is where this whole ruling came into picture. So statement 2 is wrong because that statement which we saw before, that was a part of your Gopalan case and that was rectified under your Menaka Gandhi case. Thank you friends. We'll see in the next part of polity discussion very soon.